As a country and as a government, we do not condone or tolerate corruption. This has always been our position. It will continue to be so. Domestically, corruption cases are investigated by the Corrupt Practices Investigation Bureau. The CPIB can investigate anyone. Thereafter, cases are assessed by the public prosecutor, who acts independently. Incorruptibility is a foundational value for Singapore. We must keep Singapore clean. Internationally, we know that there are many places in the world where corruption is endemic and the business environment is very different from Singapore. We cannot be a global policeman. Singapore companies have to operate in all kinds of environments, but as a matter of principle, we expect that they must do so while keeping their systems clean and complying with the laws of the countries where they operate. They must develop ways of operating which enable them to do this. They cannot lower their own standards of integrity, and they must not bring back to Singapore practices alien to the norms which we have established with such great effort here. Let me now address the questions asked. How we handle allegations of corrupt acts overseas by Singaporeans or Singapore companies depends on a number of factors, including whether the case is connected more strongly to Singapore or to other countries, any practical or legal difficulty in investigating the case, bearing in mind that the evidence will mainly be overseas, any actions being taken by third countries and the legal and regulatory tools they are bringing to bear, and any cooperative mechanisms between Singapore and the other countries involved. In handling the Keppel Offshore Marine, or KOM, case, the authorities in US, Singapore, and Brazil worked with each other and reached an agreed approach. There was no three-nation plea bargain agreement, as Ms. Lim puts it. What happened was that each jurisdiction acted under its own domestic laws, but in coordination with the other two jurisdictions. In the US, the Department of Justice, or the DOJ, entered into a deferred prosecution agreement, the DPA, with KOM. This is an agreement under US law between KOM and the DOJ. Under the DPA, KOM has to pay a penalty of US $422 million. The amount was determined in accordance with US sentencing guidelines. The DPA, which has been published, sets out how the amount was arrived at. Among other things, KOM was given maximum credit for its full cooperation with investigations. Out of the US $422 million, 50% would be paid to Brazil, 25% to the US, and 12.5% to Singapore. The last 12.5% is payable to Singapore, but subject to any further penalties the Brazilian authorities may impose. In Brazil, the Federal Public Ministry entered into a leniency agreement on similar terms to the US DPA. In Singapore, the public prosecutor directed CPIB to administer a conditional warning on KOM. In reaching this decision, the public prosecutor considered the following factors. First, that KOM had voluntarily reported its internal findings to CPIB and AGC in September 2016 and had cooperated with all three jurisdictions in the investigation and resolution process. That KOM had also indicated it would voluntarily agree to the US DPA and the Brazilian leniency agreement, and that the key elements of this case, in particular, the recipients of the bribes and the projects connected with the bribes, occurred outside Singapore, and the jurisdictions concerned are also acting against KOM in coordination with Singapore. A conditional warning allows Singapore to impose on KOM conditions that are closely aligned with the terms of the US DPA. If any of the conditions are breached, KOM can be prosecuted. The aligned approach results in a robust resolution to KOM's case. The trilateral resolution requires KOM to pay a total of US $422 million. If KOM fails to pay the penalty, there will be consequences under the US, Singapore, and Brazilian law. Of the US $422 million, KOM must pay US $52 million to the Singapore government within 90 days. Another sum of up to US $52 million must be paid to the Singapore government within 3 years from the date of the conditional warning, after taking into account any further sums to be paid by KOM to Brazilian authorities. Any penalty or claim that KOM might be subject to under Singapore law would be far less than what KOM is now liable for under the coordinated resolution. Furthermore, KOM is also required under the US DPA to strengthen its internal controls and compliance and anti-corruption programs. The current resolution therefore achieves more than what we would have been able to do if we had proceeded against the company solely under the PCA. Mr. Pritam Singh and Mr. Peng Huat asked about the action to be taken against the individuals concerned. As AGC has stated, investigations into the individuals concerned are ongoing. The Singapore investigations are conducted on the same time frame as the US and Brazilian investigations and go back to 2001 when the corrupt acts first took place. There is no agreement, whether in the DPA or otherwise, which prevents the disclosure of the individuals under investigation. However, for criminal investigations, it is standard practice in Singapore and in many other jurisdictions not to identify individuals under investigation. This is for the simple reason that investigations can lead to the conclusion that no offense is made out or that prosecution is unwarranted, in which case disclosure would have been prejudicial to the individual concerned. Individuals will be identified if and when charges are preferred in court. As for the investigation's timetable, this is not a case where CPIB and AGC are acting alone in a domestic case. This is an international case where many different investigating agencies are involved. The case involves many projects in Brazil and goes back many years to 2001. Most of the evidence, including documents and witnesses, are located in different jurisdictions, including Brazil and the US. Legal proceedings have also taken place in these jurisdictions. AGC needs evidence from these jurisdictions, and it has sought assistance, and it is continuing to work with foreign authorities. AGC has asked for certain information from them, and some of its requests are still pending. AGC anticipates that further requests will have to be made as the investigations develop. AGC is also working on a request for mutual legal assistance. This is a procedure whereby one country formally seeks assistance from another to obtain or secure evidence for use in its own investigations and proceedings. This request will be reviewed and administered by the courts of the foreign country. How quickly and to what extent these requests and applications will be processed is a matter for the jurisdiction to which the request is made. Likewise, any incoming requests from foreign jurisdictions would also have to be considered and acted upon. Obviously, the intention is to move as expeditiously as possible. However, as I have explained, not all aspects of the investigation are within our control. Only after the investigations are completed can the AGC properly assess the case and decide on the appropriate response. This is something for the public prosecutor to decide independently. How the public prosecutor decides will depend on several factors, including the culpability of each individual, the available evidence, and what is appropriate in the circumstances. For example, it will be important to determine for each individual what he knew, the extent of his involvement, his motivations, any personal benefit he obtained, the circumstances under which the relevant acts took place, and any cooperation rendered. Mr. Pritam Singh asked for statistics on concluded or ongoing investigations into corrupt practices by government-linked companies, by overseas and local authorities. I cannot speak for what foreign jurisdictions may be doing. Insofar as Singapore is concerned, past investigations which have resulted in prosecutions are a matter of public record. We do not comment on ongoing investigations, if any, for good reason, so as not to jeopardize the investigations or prejudice individuals or companies if it turns out that no offense is disclosed. Suffice to say, if there is good reason to investigate, the authorities will do so, whether or not the company is a government-linked company. For example, from 2014 to 2017, 7 former ST Marine officers were investigated and subsequently charged and convicted for giving corrupt payments to secure business and for other offences under the Penal Code. Finally, Mr. Singh asked about the role of government and Temasek Holdings in relation to government-linked companies. The government's relationship with Temasek Holdings is that of a shareholder. Temasek is likewise a shareholder of Keppel Corporation with a minority stake of about 20%. The government does not interfere in nor influence the business decisions or operations of Temasek and its portfolio companies. Likewise, Temasek does not interfere in the business decisions or operations of its portfolio companies. These are the responsibilities of the respective companies' boards and management. Temasek holds the boards of its portfolio companies responsible for running the companies honestly and competently. If the boards do not perform, Temasek can, collectively with the other shareholders, change the board. To reiterate, the government expects all Singapore companies, their officers and their employees to comply fully with the laws of Singapore and the laws of the jurisdictions in which they operate. They have to find ways to keep their own systems clean, even when doing business in complex and challenging environments. Above all, they must not import corrupt practices into Singapore.
Ms. Sylvia Lim.
Thank you, Deputy Speaker. I have 4 supplementary questions for Senior Minister of State. Earlier in her response, she mentioned that I was not correct to categorize the arrangements reached between Keppel and the Singapore authorities as a 3-nation plea bargain agreement. What we read, however, from the statement by CPIB and the AGC in December is that this deferred prosecution agreement in the US was reached, of course, with the US government, but in discussion with Brazil and Singapore. And as part of that global resolution, Singapore was issuing a conditional warning to KOM here. So my question is she actually saying that these agreements that we have reached with Keppel for the conditional warning were not taken in consultation or as part of arrangements with the USA and Brazil, which seems to be what the statement is implying, and that we reached it independently, and we could have actually gone on to prosecute KOM if we had wanted to. It would not be in breach of any global arrangement. So that's the first question, whether we're completely free to decide whether to prosecute or not in these discussions with Brazil and the US. Second question is, she mentioned in her response that the conditional warning, of course, carried certain undertakings from KOM, which were closely aligned to the undertakings in the US agreement, but she did not really specify whether they were coterminous or whether there were variations. So I'd like her to probably give some examples of some of the key undertakings that we have included in the Singapore agreement with KOM. The third question is, in her roundups or in her response, she mentioned that by reaching this arrangement, we would have achieved much more than we could have on our own. Now, the CPIB and AGC statement say that KOM is being given a conditional warning in lieu of prosecution under the Prevention of Corruption Act. I'm not sure whether the Senior Minister of State in her response was actually saying that it would have been quite difficult to successfully prosecute KOM because the evidence was overseas and so on and so forth. In which case then, it's a question of whether this in lieu of prosecution really means anything here. And finally, of course, I think the government would be aware that there's been much interest in this case. And looking at what's been happening to Keppel as a GLC, as a corporate entity, given the large sums of money involved and the damage to our reputation, people perceive that they're just being given a slap on the wrist, whereas it's a daily affair that individuals who are not well connected, they are prosecuted for corruption offences involving $10 or $20 and they go to jail. So I'd like the government to respond to that, because I think there is some public concern about this, what is perceived to be some lenient treatment being given to KOM.
Mr. Deputy Speaker, I thank the member for her questions and the opportunity to clarify certain things. Her first question was whether I had, in my reply, suggested that the actions taken by the AGC were not done in consultation or coordination with the other authorities. I did not say that at all. Let me just read what I actually said. I said that there was no three-nation plea bargain agreement. What happened was that each jurisdiction acted under its own domestic laws, but in coordination with the two other jurisdictions. What I was trying to explain is the legal basis or the legal concept behind it. Because when you say three-nation plea bargain agreement, it suggests that there's either some kind of agreement or treaty to which all three countries are party and we're acting under the same instrument. That is not the case. What I was seeking to establish was that each country is acting in accordance with its own laws. But even whilst acting in accordance with its own laws, they reached a coordinated global resolution. So that is what I said in the main reply, and the intent of it was to explain the underlying basis, which is that each country is actually acting in accordance with its own domestic laws. That is why in the US, they're acting under the Foreign Corrupt Practices Act, and they are using the DPA mechanism. In Singapore, we use a conditional warning and the PCA, and of course in Brazil, they had a leniency agreement. So that's all that was being said in relation to that. The second question was in reference to the main answer, where I said that the terms of the conditional warning were closely aligned, and Ms. Lim wanted to know whether it was coterminous and essentially asking what are the terms of the conditions. It is not our practice to disclose terms of conditional warnings, not just for Keppel, but for all cases. So in other words, conditional warnings are things which have been given in the past by the agencies, but as a general practice, we do not disclose its exact terms. What I can say is what I have said, which is that it is closely aligned with what has been done in the US. The third question was whether we have when I said that we have achieved more than if we were acting on our own and acting in lieu of prosecution. And if I could just clarify with Ms. Lim, her third question, what was the purport of that?
Yes, sir. What I was asking was that the Senior Minister of State had said that some of the considerations in such transactions which take place primarily overseas and whether we decide to prosecute locally is, for example, whether our local authorities might have difficulties getting the evidence or witnesses locally. That's what I understood her to have said. So my question was that when the CPIB and the AGC say in their statement that they are giving a warning in lieu of prosecution, is it a real risk of prosecution, or is it a case where there will be difficulties and that's why we are saying that we're not prosecuting them, but in reality, the case will be difficult to mount?
Oh, I thank the member for her clarification. In this particular case, since Keppel has actually come forward and cooperated, it has, in effect, as a company, the company has admitted its part in this. So the next question that comes or that arises is, do you prosecute or do you give a conditional warning in lieu of prosecution? And in this particular case, it was decided to give a conditional warning in lieu of prosecution because of the factors which I had outlined earlier. But the point I was making when I talked about being able to achieve more than we would otherwise would have been able to do if we proceeded solely ourselves is for any number of reasons. But first, the maximum fine under the Prevention of Corruption Act is $100,000 per charge. So this wouldn't get us anywhere near the penalty under the global resolution or even Singapore's share of the current penalty. And with respect to disgorgement, there will be issues of which country gets what. So under the global resolution, what it means essentially is that we're able to achieve all the things that we would have been able to do with prosecution, but even more. And in addition, under the USDPA, there's requirements for an enhanced compliance program. So all of these are things which that we have obtained, which is more than what we would have been able to obtain if you proceeded solely under the DPA. That is what I meant by that. Then let me proceed now to the last question, where Ms. Lim suggested that, people may be getting off lightly because it's a conditional warning. Now for this, I think it's important to understand that there are actually two different things. First, there's the company. Second, there's the individual. Insofar as the company is concerned, it is not a light thing at all. They have not got off lightly. They paid something to the tune of, in the DPA it says $55 million worth of bribes. They have been slapped with a penalty of $422 million. That's something like 8 times whatever they would have paid out. They have been subject to an enhanced compliance regime. They have, as I've pointed out, we've actually achieved more than what we would have been able to do if they were prosecuted solely under the PCA. So very clear, and the company itself has obviously taken remedial actions. So as far as the company is concerned, make no mistake, there has been a heavy price to pay, and deservedly so. With respect to the individuals, as I explained in my earlier reply, investigations are still ongoing. That outcome has not been determined. Nobody has got off or not got off, as the case may be. That is something that the public prosecutor has to decide, and I have explained some of the challenges that the public prosecutor is facing in terms of getting the evidence, but that is something we have to let the PP deal with independently. But let me just say one other thing on this, which is that it is not a matter of letting individuals off lightly. We have, in the past, taken actions against people irrespective of their status. We had, in the ST Marine case that I mentioned, all seven individuals were senior management, including former presidents of STM. There was Patrick Lee, he was the former group financial controller of STM. There was Ong Teck Liam, former group financial controller. Han Yu Kwang, former chief operating officer. Mok Kim Wang, former senior vice president. Tan Mong Seng, former president commercial business, STM. Chan Chong Tek, former president, STM. Si Long Tek, former president, STM. Government officials and politicians have been investigated in the past by CPIB and charged. These include a Minister of State, Wee Tun Boon, sitting and former MPs, Pei Yu Kok, Chu Wee Kiang, a SEDF Commissioner, Peter Lim, an NKF CEO, Titi Dure, and a Deputy Chief Executive of PUB, Choi Hon Tim. There was a Cabinet Minister, Tay Chang Wang, who took his own life after CPIB started to investigate him. So there's no doubt about CPIB's record, and there's no doubt that we will take action if there is cause to do so.
Dr. Tan Wu Meng.
Mr. Deputy Speaker, with your permission, I'd like to ask 3 supplementary questions. As background, if a prominent company, especially one linked to government, fails to uphold the law and proper standards of conduct wherever they are, it hurts our national reputation. As my residents have told me, it's not enough just to win or get the job done. My first question is, even if the government or Temasek holdings do not manage the day-to-day operations of GLCs, what measures are there to send a clear signal that Singaporeans and Singaporean companies overseas must not engage in corrupt behavior, whether directly or through proxy agents? My second question is, does the government have a view on whether KOM should conduct a clawback of bonuses paid out to ex-employees implicated in illegal behavior? And even if KOM has no legal means for clawback, should such bonuses be subject to forfeit by law under the Penal Code or the Prevention of Corruption Act, if not so already? Thirdly, for government tenders, what incentives are there to shape the behavior of proxies and agents to minimize the risk of illegal activity? For example, should there be punitive liquidated damages written into a tender in the event that the contractor is found to have breached the law either in Singapore or overseas?
Mr. Deputy Speaker, I thank the member for his questions. I certainly agree that it does hurt our reputation, and for that reason we do not condone this. We are extremely disappointed as well in what has occurred. With respect to the first question that the member asked about what measures Temasek can take to send a clear signal to Singaporeans and Singaporean companies, as I said, and I repeat, the government expects Singapore companies and Singaporeans to do business honestly and lawfully, even in complex environments. And for Temasek, their position is that they foster an ethos of integrity and good governance and sustainability, and they too do not condone improper conduct and malfeasance. So Temasek expects companies in its portfolio to abide by sound corporate governance and robust codes of conduct and ethics. Temasek holds the respective boards and managements responsible and accountable for the day-to-day decisions and actions of these portfolio companies, but Temasek does not direct the day-to-day business decisions or operations of the Temasek portfolio of companies. But what Temasek can and does do is to conduct regular roundtables, forums, educational programs, all essentially directed at encouraging not just its portfolio companies, but all other companies to keep and maintain clean systems and avoid corrupt practices. The second question the member asked was about whether we have a view on whether KOM should claw back bonuses paid out to ex-employees, etc. The government does not intervene in internal corporate disciplinary actions. This is a matter for KOM and its board, but as stated in the US DPA, KOM has imposed about US $8.9 million in financial sanctions on 12 former or current employees as part of the disciplinary process. The third supplementary question, I think, was with respect to tenders. Government tenders explicitly state that tenderers can be debarred if, for instance, they are convicted of corruption by our courts. Debarred entities will not be eligible to participate in any tender by government agencies for a period of time. The directors of a disbarred company will also be debarred, and for any new companies or businesses they set up during the debarment period will also not be considered for award of tenders. Beyond disbarment, the track record of a supplier is typically an evaluation criterion in government tenders. Any known facts that reflect on the commercial integrity of a supplier will be taken into account in evaluating the supplier's track record.
Mr. Pritam Singh.
Minister, I've got 5 questions for the Senior Minister of State. The first question is, in view of the government status as the largest single shareholder of Keppel, will Temasek Holdings call for an extraordinary general meeting with a view to pursue civil action against board members and senior executives found responsible for the bribery scheme for breach of fiduciary duties and to seek equitable compensation from those responsible? The second question pertains to the questionable P61 contract, which amounted to hundreds of millions of dollars, and it would have likely required board approval for it to have been approved. Did the Keppel board, is the government aware whether the Keppel board gave the CEO broad powers to enter into the contract? If not, what is the nature of the board's oversight and their culpability in the bribery scheme? Is this something the public prosecutor or the CPIB is going to look into, or is this a matter for shareholders to consider? Thirdly, in its information release, the US Department of Justice shared that a KOM subsidiary in Singapore paid the bribes amounting to $70 million into an entity based in Florida and Miami. What is the name of this subsidiary? And this is just a question of fact. And who are the officers of this subsidiary? Fourthly, A former Keppel CEO and senior advisor, Mr. Chu Chao Bing, was the Singapore ambassador to Brazil from 2004 till 2016, I believe. Was Mr. Chu removed as ambassador because of his involvement or knowledge of the bribery scheme? And if so, and I stress if so, which month or year did the government first come to know of Mr. Chu's involvement? Finally, is the CPIB or the public prosecutor investigating whether Mr. Chu used his position as ambassador to dishonestly assist Keppel secure contracts corruptly in Brazil? My final question pertains to the matter of the identities of the individuals identified in the Deferred Prosecution Agreement. There is a dissonance between what the public reads in the newspapers for individuals who are being investigated. For example, the general manager of Ang Mo Kio Town Council, no charges, I understand, have been preferred against him yet, but his identity, his name is well known to the public. How does the minister reconcile that with a non-disclosure of the names of the individuals involved in the Keppel matter? Thank you.
Let me just deal with the last question first, which I think he wanted to know, how does the government deal with the fact that the names are out there? Government's position is very simple. The government deals with the government's actions. So the government's actions are, when investigations are ongoing, we don't disclose identities of people being investigated. What other people may say outside, what other information may be floating outside, what other comments may go on in social media, that is separate. But as a government, as an investigation authority, the government does not disclose names of individuals who are being investigated, and we are not alone in that. All civilized jurisdictions who have rule of law uphold that principle simply because, as I mentioned earlier, you don't want to prejudice either the investigations or the persons being investigated, depending on how the investigation might turn out. With respect to the first question, I think Mr. Singh asked, why does the government, can the government, as a shareholder, call a meeting and I think ask for a resolution to be passed to commence civil action? I think that was the thrust of the question. Let me just correct a few factual inaccuracies here. First, government owns 100% of Temasek. Government is not a direct shareholder of Keppel. That's number one. Temasek owns just over 20% of Keppel Corporation, which is not the entity in question here, which means there's 80% of other shareholders. Keppel Corporation then owns 100% of KOM, which is the entity in question here. So the general principle of corporate governance, with which Mr. Singh is familiar as a lawyer, is that the shareholders deal with their companies in which they have shares at the shareholder level. Shareholders appoint the boards. The boards then, depending on whether the members are executive, non-executive, it's their business to make sure that the policies, etc., for the company are proper, that governance is proper, and then the day-to-day operations are done by the executive team or the executive management. As I've mentioned earlier, in this particular instance, the government and Temasek does not interfere in the day-to-day running or management of the companies, of Temasek portfolio companies. What I can say, and what I can point Mr. Singh to, is what is already in the public domain, which is in the DPA, which is that the company, this is paragraph 4D of the DPA, which I'm sure Mr. Singh is familiar with, the company has engaged in extensive remedial measures, including taking disciplinary action against 17 former or current employees in relation to the misconduct described in the statement of facts. They have caused 7 employees who participated in the conduct described in the statement of facts to separate from the company. They have issued demotions and/or written warnings to 7 employees who failed to detect the misconduct and failed to take appropriate steps to mitigate corruption and compliance risks. And they've imposed approximately 8.9 million in financial sanctions on 12 former or current employees as part of the disciplinary process, and have conducted individualized anti-corruption and compliance training for 6 employees. Anything further than that is a matter for the Keppel Group, or for the company in this case, to determine, not for the government. Now, going back to, I think Mr. Singh had a couple of other questions. On the P61 contract, he asked whether, I'm sorry, could you just clarify your question on the P61 contract?
Senior Minister said the question really pertained to the nature of the board's oversight over that contract, and what would, if indeed they had knowledge or they were involved in that contract, what is the nature of their oversight and their culpability in the bribery scheme, and specifically, is this something that the CPIB or the public prosecutor is looking into?
That is actually not so much a question for the government. That is a question of, as to what was known, not known within the Keppel Group is really a Keppel matter. I think the only thing that I can do here, which would be useful, is to point Mr. Singh to one of Keppel's media releases, where Keppel said that the current boards of directors of Keppel Corporation and its unit, KOM, were not aware of the illegal payments made to secure projects in Brazil. Now, that is Keppel's position. As far as the government is concerned, as I have explained, the government is shareholder in Temasek. Temasek has a just over 20% shareholding in Keppel Corporation, and the operations of Keppel are run by Keppel itself. Mr. Singh also had a question on the name of the subsidiary company. I do not have that information with me, and he asked about the circumstances in which Mr. Chu Chao-bing may have stepped down as ambassador. I do not have that information. What I can say is that he has stepped down and he is not involved in an ambassadorial role at the present time.
Senior Minister of State is beginning to repeat herself in her answers already, so I'll allow two more supplementaries. Engineer Lee Biwa.
Thank you, sir. $422 million is a huge sum. I would like to ask SMS, who will pay the $422 million if KOM is unable to pay? Will it be paid from our government budget? Thank you.
Mr. Deputy Speaker, the monies will have to be paid by Keppel. It would not come out of the government budget. There would be no impact on the government's fiscal position. Temasek's 20% stake in KOM is just one part of its portfolio. The government's spending limit in relation to its reserves held by MAS, GIC, and Temasek depends on the long-term expected return on those assets. It's not based on actual cash contributions of the entities to the government.